Hi everybody, hopefully you can all hear us okay on LinkedIn. Please pop a little hello and thumbs up if you can hear us in the comment section. This is the next instalment of my Smooth Accounting podcast, and today I am so excited because I've got Ryan Lisk with me from Hybrid Legal, who is my trademark expert and should be the world's trademark expert. Hi Ryan.
Good morning, everyone, and thank you so much, Jerry, for inviting me on this morning. Apologies for my voice. It's a little bit coarse at the moment, but I promise I'm not hungover.
You might want to go for a drink after this just to get over it, but I'm sure you'll be fine. Thank you so much for coming on. So today we're going to talk all about trademarks and go through some common questions that people want to know the answers to. Hopefully we will get some questions in the comment section. So anybody listening, if you've got any questions at all for Ryan, please pop them in the comment section and we will get around to those and we will answer them for you. I'm saying we. Ryan will answer them for you. I will ask them, Ryan will answer. So before we kind of get into it all, I'm sure everybody wants to know, tell us a little bit about yourself and how you got into this field of work.
Sure, thank you, Jerry. So I'm Ryan from Hybrid Legal. I started Hybrid just over 8 years ago now. Can you believe that? How that time's flown. And I say, can you believe that? Because I actually met Jerry when I first started out, when it was just an idea. Yeah. And it's lovely to be sat with Jerry 8 years later, both of us with, businesses that we're growing. And, the reason why I started Hybrid was to offer businesses, particularly SMEs, the ability to use legal services that are nice and clear, easy to understand, and fundamentally at a price that's fixed and very transparent. So that was my goal. And 8 years later, we're doing really well with that now, and we've had some great businesses. So yeah.
Oh, I just cannot believe it's been 8 years. I literally can remember the meeting in my office where I used to work, where I was employed. I think we'd met at a networking event. That's or right. Something, and then we said, "Oh, we'll get a coffee and we'll have a catch up." And then you said, "Yeah, I'm going to start this law firm. I'm going to start Hybrid Legal." And to think that was 8 years ago, just absolutely mad. Like,
I had a proper baby face then. I had no beard.
Yeah, we were both a bit younger then, but it's fine. So great. So I obviously have used Hybrid myself for Smooth to get the trademark. So I just wanted to tell everybody a little bit about that process, because I honestly think, and speaking from experience, that people think, I can just do it myself and it's pretty straightforward and just go online. And I genuinely was going to do that. And I'm so glad I didn't for so many reasons. I obviously didn't have Smooth as a name at the point that I contacted you. I just said, look, I want to rebrand. I'm thinking about trademarking, obviously, before I do that, so that I don't struggle, further down the line. And the last thing I wanted to do was go through the whole rigmarole of rebranding and then find out that actually someone else is already using that or trademarked that or whatever. So I came to see Ryan with 3 ideas. Smooth wasn't one of them. I came to you with 3 ideas and you said, look, give me 3 names. And is that the sort of thing you always do with clients? Like, just give me a few, the background checks, or depend?
Yeah, it does depend. But I think if it's a client that's trying to come up with a complete new brand, what I'll say to them is, look, you can go away and do a little bit of homework yourself to begin with before you spend any money with me. And that homework is, try and come up with a brand and do some basic checks, such as give it a Google, look on Google, see what's coming up, see if you can get the domain name, have a look at social media, see if it's available on there. But fundamentally, you're looking out for any businesses that are going to be similar to what you're going to be offering under that name. If you spot another business that's using that name, go on to the next name on your shortlist, so you filter it down. So in your case, Jerry, we got down to 3, didn't we?
We did, and I was like, here's 3, and I knew which one was my favourite, which I'm happy to tell everyone. So I wanted it to be Buzz Accounting, B-U-Z-Z, Buzz Accounting. So I remember I came to the meeting, sat down, and you said, which one's your favourite out of the three? And I was like, Buzz. And you said, okay, try not to get your hopes up. I think that was your way of like just letting me down gently, because I was like, oh. And then obviously you presented the report on the three names, but Buzz, the issue being that Buzzercott is a very well-established, massive accountancy practice with the trademark UK, I think even Europe they had as well. And that was just an absolute no. And I just didn't, again, naive, but I just didn't realise, I'm like, there's no Buzz Accounting. I've looked, Buzz Accounting's available at Company's House. There's no website Buzz Accounting. I can't see any other firms. And again, I think that is so important for people to understand this. It's not just it doesn't have to be an exact match. If it's close enough that people would, you explain this because I'm not going to explain it right.
It's a good point. I mean, when it comes down to looking at what you need in order to register a trademark, there's three fundamental points that you need to make sure you can tick. The first one is your name can't be descriptive of what it is that you're going to be selling in connection with that name. So in your world, Buzz wasn't descriptive of accounting services, bookkeeping and tax advisory services. The next step is looking at, is it a particular name that's commonly used in your industry? So, a good example, if you're a plumbing business and you want to call your plumbing business Watertight Plumbing, we all know that watertight is a commonly used term in the plumbing industry to describe the outcome of what that plumber has just done for you. He's made it all watertight for you. So you can't protect a particular name that's commonly used. And for you, Buzz wasn't commonly used. The big problem was the third point, which is it cannot be similar or identical to another trademark that's already been registered. And when we look at that, we're looking at, visually, verbally, when you pronounce it, are there similarities there? And when we were looking at that earlier trademark that you made reference to earlier, Jerry, we thought actually there's a bit of a risk here that they could raise their hand to say, not happy with that, I'm going to... Sorry, that was my... But
just make sure everyone's awake that's listening.
Got us with you, so apologies, but yeah. So and a good example of verbal similarity. So Cadbury's the chocolate brand, major brand, and another chocolate bar manufacturer tried to register the word Caprice. So Caprice, like the singer, and Cadbury were able to successfully actually prevent that trademark from going through, and because of the verbal pronunciation of it. So yeah, it can be a bit of a minefield.
Oh, absolutely. And I learned so much from doing the process of trademarking. Like, I'm so glad I didn't do it myself, because little things like when you eventually registered Smooth for me, it was Smooth in plain text and not the Smooth Accounting logo, which naturally I would have trademarked what I think is my brand in that Smooth Accounting purple and white trademark logo, sorry. And so just to backtrack a little bit, we didn't go for Buzz, obviously, for that reason, and then thought about it some more, came up with some more ideas, eventually went with Smooth. And when I approached you and I was like, I've got a new name, please tell me this one's okay. You had a couple of reservations, I think, about it. Well, actually one reservation, I would say, and that was that it could be descriptive of accountancy services. Would people describe their accountancy services as smooth? Perhaps they might. It was a really smooth accounting process or whatever. So you said, like, we can try, but it possibly won't get accepted. And you were, I think, would you say you were 50-50 on it, or were you more 60-40?
I always want to under promise and over deliver. So I think with your one, it could have gone either way. And this is the challenging thing with trademarks. So you apply to register your trademark with the UK Intellectual Property Office in this country. So they're very much like Company's House. And it depends on the examiner on the day, in some cases, in terms of how they're going to interpret it. So you'll have an examiner who'll look at the application. And we've had some examiners in the past that have allowed a trademark that we've said to the client, look, best of luck with this. We think you're taking a punt here. And they've allowed it to go through. And then other marks at times where we thought actually it's probably a good chance, and actually the examiner has disputed it. We've eventually got it through, but sometimes we look at obviously the way that they come up with their decisions, and sometimes it's a challenge. So, but I mean, fair play to you for wanting to take the punt, because it's worked out really well for you. And
yeah, it really has. Yeah, and again, another thing I didn't realise, and I probably would have got wrong, is I would have trademarked smooth accounting. Said no, we're going to trademark smooth, the word smooth, and I just wouldn't have thought. I would have thought my business is called Smooth Accounting, so that's what I'll trademark. But so much more protection in just trademarking the word smooth, because stopping anybody from trading as smooth in the sectors that I obviously have protected, being like the accounting related ones, and also using it in their logo. So it's both, and I wouldn't have known to just trademark smooth. I would have done smooth accounting. I've done it on my own.
Yeah, and that's a really good point in terms of where it pays to take advice from somebody that does it for a living rather than taking a punt yourself. That's not to say that if you have a go yourself it won't work, because in some cases
no,
but
it might.
obviously in your case, I remember talking to you about your overall vision and where you wanted to go with the business. And the most dominant part of the name undoubtedly is smooth. Accounting is just generic. It's just the description of what it is that you're doing. Whereas smooth, that's the dominant part of the name. So the fact that we've got that protected, that gives you lots of avenues to go down now within the classes that we've protected your trademark under, most notably for obviously accounting, bookkeeping, tax advisory. And I would say the same really for anyone listening. Have a look at your name and look at really what is the most important part of the name. It might be, I'm just trying to think of a very distinctive local brand.
Think on the spot.
Yeah, it's
impossible.
Have a look at your name, and you'll be able to identify really what's the most distinctive part of that name. Because if you've got a part of your name which just describes the goods or the services that you supply, I would almost disregard that and focus purely on the distinctive part of it and look at protecting that, so it gives you a much wider range of protection.
Yeah, definitely. Yeah, it was such an interesting process, and I learned so much. And I remember where I was when you phoned me to tell me that the trademark had been accepted. I was in a cab in London.
I was
away for like the weekend or something. You phoned me, and I was like, "Oh, Brian's phoned me." And you said, "Do you want the good news or the bad news?" And I said, "Bad." And you said, "The bad news is you're going to have to." Continue with the name, all that's involved in changing your name now, and the good news is that it's been accepted. And you were like, I can't believe it, like I really thought we might struggle with that, but yeah, it's got through, so yay.
Yeah,
and the rest is history.
Exactly. And another point that you mentioned just a moment ago was obviously, if you'd have done it yourself, you would have just trademarked your logo. And that's quite a common misconception. A lot of people, when they do their own trademark applications, they'll just upload a copy of their logo and they'll think that, brilliant, that's me done. What that's actually protecting is it's just protecting your particular logo. That's it. It's protecting the visual design of that logo, the layout, the style. You might have a particular font that you've used for a particular icon within your logo. It's that visual representation that you're protecting when you trademark a logo. Whereas when you actually look at plain text, like what we've done for your trademark for smooth, you're now protected in your industry. So if somebody else wants to enter the market and use smooth, but in a completely different color palette and in a completely different logo to yours, but they're fundamentally offering the same service as you, we can go after them. Whereas if it was just for your logo, they could argue that actually, technically, our logo and color palette is completely different. You don't have exclusivity to smooth. You've just got smooth as part of a logo device. Challenge me, so it's eliminated that risk for you, which is good. And that's what I always recommend to clients. If we can get away with getting plain text, brilliant. Sometimes we can't do it if the name's really descriptive. So if the client has got a name that describes what they do, or it's quite commonly used in the industry, that's where I recommend looking at a logo device as a fallback option. It's not the best solution, but it is an option.
No, something, I suppose.
Yeah, and also, if in fairness, if their particular logo is really distinctive, so if they're, a fashion brand like the Nike swoosh, for example, or Adidas, or that they could be selling anything where their particular device is very important to their business, it acts as a badge of origin, then that's absolutely a good reason to just protect the logo in itself.
Yes, of course. Yeah. Cool. And that leads me nicely on to an issue I found myself with when a well-known company, who shall remain nameless, approached me and said that my logo, so it wasn't an issue with my name, but my logo was basically passing off as their logo because of the similar color pattern, basically, and font and everything. Obviously panic stations. And I phoned you. Oh my God, Ryan, what are we going to do? We're going to have to change my whole company name and everything. And this company, I would just like to point out, is totally unrelated to accounts or tax or anything, even similar to anything that I do. Totally different industry. So we went back and said, being a bit cheeky, you're in a totally different industry. I think they had the copyright, was it, or was it the trademark for they had the trademark.
So what they had a registered trademark, but their issue was with just how close a match the visual similarity was.
That was it. Yeah.
A little bit concerned that their customer base and your customer base would be confused as to the source. I think they were thinking that some of their customers would be thinking that they've now branched out into the world of accounting. So that was their concern. And obviously we looked at it, didn't we? And we actually came up with a very good compromise with them.
Very good compromise, which was, because originally my logo, which, I mean, to be fair, my logo I have different color there. So I originally had white on a purple background, which is what they had an issue with. I also had purple on a white background. I've got white on a black background, and the other way around. I've got it in various different formats. I've got a grey hoodie on here, so I've got purple and grey. So we agreed, look, I'm a very, very small business in comparison. We're in totally non-competing, I think you said non-competing industries. Let's not be ridiculous. I won't use the white writing on a purple background anymore. I'll switch it around and I'll use purple on a white background, which they were fine with, and it was a good outcome. I was very happy with the outcome. I just didn't want to have to change my branding, and I guess it was very frustrating for me because, and again, I think this is where people don't always understand. I think, well, I've got a trademark, so they can't do anything, but it's not that black and white. It isn't. There's loads of different elements of it. Like, yes, I've got a trademark, but they also have a trademark for the logo. So it's but the colors were different, and I thought the colors were different, and the design of the logo was different. So we ended up with a good compromise on that. But it was, and when you sort of did my letter reply, it was like, actually, we've also got the trademark in our industry, and we were quite firm but fair, I thought, with our reply.
And I think that's important. And I think the reason why we were able to get the result that we wanted was because we listened to all of their concerns, and we addressed them, and we compromised where it was necessary, and we were firm in areas where we had some good strengths. I think where some people go wrong with their negotiation, particularly if they receive a cease and desist in the post, when they read it, they think, oh my God, that's horrendous, and it goes into fight or flight mode. And it's they go into flight mode, bury their head in the sand. That's where it's not a good place to be. Either take advice or have a chat with the person that sent it over to you. I would always recommend taking advice, of course, but it's always worth talking it out, because usually what they're claiming for in the letter, certainly in my experience over the years, isn't what the end result is. We've usually, sometimes it's a chest beating exercise, it's all scary, but then when you actually dig into it and have a chat, you can often make compromises, and the other side will make some concessions for you as well, depending on how that conversation goes. So I think there's a saying, isn't there? You know, you can catch more wasps with honey than you can vinegar. So yeah.
Yeah, and that's the thing. I think I got the letter and just freaked out. Well, I did, and thought it was the worst thing in the world. And you were like, "It's actually quite a nice letter. I've seen, you know, cease and desist. You've got 7 days, take everything down, and that's it." And it wasn't. It was actually, you know, given their dues, I thought it was quite a sort of reasonable letter in hindsight, because I didn't have to change my brand. In hindsight, I thought it was a reasonable letter. So yeah, so that was a great result, and I was very, very happy. But it just shows that, you know, you're not always 100% protected, and you do need to think about how you respond. And like you said, you know, get some advice. Like, don't just say nothing, and also don't go back going mental. Like, just sort of, you know, take some advice and go from there. Which is exactly what I did with the next scenario that happened. I feel like everything just happens to me. Is this just me, Ryan? Do other people have all these things? Do other companies go through these things? It's just smooth.
I mean, but it's not. It's quite common, more common than you think, actually. Okay. So yeah.
I'm just pleased I must have chose a good brand, because, you know, otherwise I wouldn't have these problems. But I got sent a message from someone who thought they'd seen me post in a Facebook group as Smooth Accountancy. I have to get this right. So I'm Smooth Accounting, yeah. So there was this Smooth Accountancy, and she said, "Oh, is this you?" And I said, "No, that's not me. Who the hell is that?" So after some digging, found out that this company was trading as Smooth Accountancy, and had very recently changed to Smooth Accountancy, like a few months prior. So again, got on the phone to Ryan. He was probably like, "What is it now?" I was like, drama number 2. And you put me in touch with Dion in your team, who was amazing. And very long story short, because I'm sure no one wants every single element of what happened, but we went a little bit around the houses. This particular chap, I phoned him originally just to say, you know, I've got the trademark, and he said, "So have I." So that phone call was very short, and I just said, "Look, you know, you'll hear off my solicitor." It turned out he was trading Smooth Feathers for a while. When I say trading as, it wasn't public. There wasn't, like, you know, he had a website page, but nobody could see it, because we certainly didn't find anything about anyone trading as Smooth. It wasn't on Google or any, you know, he doesn't come up on Google or anything like that. But he did have Smooth Feathers as a limited company from like 2014. When speaking to Dion, he said, you know, you've got to have goodwill. Can't just say that it's your name. You know, you have goodwill in your brand. And he ended up dealing with the chap, and we ended up settling further down the line on he can go back to Smooth Feathers, but he absolutely cannot be Smooth Accountancy. That was almost identical.
Yeah, that's right. And you know, we've ended up with the result that we wanted, which is good. And I think the other side are happy as well with how that was handled, which is key as well.
Yeah.
But,
yeah. And we agreed they would transfer the trademark to me, because they did actually manage to, and that's another thing, like they managed to trademark Smooth Accountancy, which I just thought, how can that happen when I've got a trademark for Smooth, you know?
But unfortunately, it can happen. It's rare. It is quite rare for that to happen, but it can happen. But the good news is we managed to get it resolved, which is a good result. So, but I've seen it go the other way, where, I mean, an example that always sticks to my mind was, you know, during the earlier years of hybrid. And I remember it was an owner of a digital agency that came to me and said, "Right, Ryan, I've just received this cease and desist. I'm a bit nervous about this because I've got no idea about trademark law. I really like my current brand. I'm really well indexed on Google. The last 3 years, I've built up a big presence locally under this name, and I don't want to lose my search rankings. Because I'm selling SEO services and pay-per-click services. It's going to be a bit of a kick if I can't say to prospective clients that I'm not myself on a decent page of Google."
Yeah.
So what can we do? And I remember going through the letter, and sadly they had him banged to rights. You know, there wasn't really any wiggle room. They had a registered trademark in place. They'd had it in place, I think at the time it was about 9 or 10 years. And there was lots of evidence that they were using it, albeit up north, still in the UK, but up north. He was based down in the south. And I said to him, right, we've got a couple of options here. They're obviously saying to you that you need to cease and desist and deliver up all infringing content within the next 28 days and change your brand. That's obviously a tight time frame for you to just completely change your brand, let all of your clients know, and get your new website up and running. So we need to play for a bit of time here and negotiate.
Yeah.
We need to see if they're willing to sell the trademark to you so we can get it assigned, or alternatively, we can look at potentially a license from them so you have the legal permission to use it down here, subject to the terms that they're happy to agree to and that you're happy to agree to. Or the third option, which is unlikely, is a coexistence. Based on this letter, I don't think that's going to happen.
No.
The fourth option is you really do start thinking about a new name and you take it as a learning curve, and we'll make sure that your next name that you choose is protected and locked down from the start. Yeah. So we tried on the assignment in terms of buying the name from them. They were not interested in that. They were not interested in licensing, and they very much stood firm and said, look, we'll give your client a bit of breathing space to change, but you know, we do have him back to rights, got to change your name. And he was devastated. I think, you know, I've seen some bad reactions in meetings, you know, over the years when I've had to break the news to someone that somebody else has got a trademark and it's going to be tricky to get it. Or it's just not trademarkable, and it does hit them quite hard. But this particular chap, he was devastated, and that was quite hard. But the good news is he got through it. He did get through it, and now, you know, he prefers his current brand to that.
Yeah.
So, you know, it's always the way, isn't it? In the moment, it feels horrendous, but it is a name. So look at Facebook.
It works out in the end.
Yeah.
Exactly. Yeah, and because I remember with trying to get this other company to stop using Smooth Accountancy, you know, they said, well, you leave me alone. I already had smooth feathers, you know, you leave me alone, I'll leave you alone. And Dion was like, no, absolutely not. My client is very, very protective of her brand and has a huge amount of goodwill, and you have literally changed your name in the last few months. Bearing in mind I've had Smooth for over 2 years now. You know, this is, which is relatively new in terms of trademarks, but still in comparison, you're piggybacking on my, you know, Dion said to him, you are piggybacking on my client's goodwill. You've changed your name in the last few months to be almost identical to a reasonably successful, well-known brand in the area, sort of thing. And they weren't that far away either in terms of geographically. So, you know, it was good. It was really good to have you guys on my side and to have Dion, you know, picking the phone up to this guy and saying, you need to get some legal advice. You know, my client is not backing down. She's not going to back down, you know. And he was amazing. He was proper like, and he was very, you know, straight with me. He said, it's not that black and white in this case, because he did have smooth feathers, but he also didn't have any goodwill. So, you know, he said it's not as ideal as I would have liked it to be. I'd have liked him to have not ever had smooth anything. Yeah. But you know, and you don't want to go to court. It's not worth it from a financial. We want to avoid going to court if we have to. So it was just, it was a great outcome again for us, and being able to keep Smooth as a brand and everything. And one thing that I learned through that process was about unregistered rights. So can you just tell everybody a little bit about the difference between unregistered rights and trademarks, please?
Sure. Yeah, no, great question. And so essentially 2 types of trademark: registered trademarks, which, you know, you have to file at the UK Intellectual Property Office. Those 3 key requirements that I mentioned earlier will apply there. For unregistered trademarks, everyone has one of those, essentially, is probably an easy way of saying it. So if you haven't yet registered your business name or your particular brand as a trademark, don't worry too much, because you do have unregistered trademark rights. The downside to unregistered trademark rights compared to a registered trademark is you haven't got a central register to point to say, there's my trademark, this is the date I filed it, the date it was registered, and these are all of the areas that I've got my trademark covered under, because you've got 45 different classes of goods and services to choose from. So it makes it nice and easy to see the scope of your trademark. You don't have that luxury with an unregistered trademark. Instead, if you spot somebody else using your name that isn't yet registered as a trademark, you have to rely firstly on the fact that you were indeed the first person to start using it and that you've got goodwill in that particular name. Goodwill in itself, I mean, you'll know this, Jerry, as an accountant, it can be quite a tricky one actually to value goodwill. So therein lies some of your expense already. The next one is there needs to be a misrepresentation. So you need to prove that the other person that's using your unregistered trademark is using it, you know, in a similar context to the way that you're using your unregistered trademark. So they're selling similar services or products, and it's causing confusion in the marketplace, you know, so people are becoming confused. And that leads on to the third requirement, which is causing damage to your brand. It might be financial damage, it might be reputational damage, but you need to be able to pinpoint the actual damage that it's causing, which again can be really tricky. And that's really where an unregistered trademark, whilst you don't have to pay the fees for registering it at the outset, you know, you can just wing it and just hope that you don't have to enforce it. You do usually have to invest quite a lot for an action of what we call passing off. So passing off is the action for enforcing an unregistered trademark. When you want to enforce a registered trademark, that's a trademark infringement claim, essentially.
Right, okay.
Whereas with an unregistered trademark, you'd be looking at the common law right of passing off. And it's quite tricky. The burden of proof is higher. It's just generally a more complex area compared to trademark infringement. So obviously both can be complex, but my number one piece of advice to anyone listening is if you can get a registered trademark, do it. It's a no-brainer. You don't have to use me. You can use, you know, a firm that you already use, speak to an expert, but certainly, you know, get it registered if you can. Take advice on whether it can be registered as well, because that can often save you quite a lot of money.
Yeah, definitely. And that's the thing as well. It's, you know, people will check the trademark register and go, oh, great, no one's got it. I'm going to register my trademark, you know, and then someone comes along that's just been trading as that, but hasn't registered it, and could have that trademark removed.
Yeah, so it's again, that's quite a tricky one to do, but it can be done. So yeah, it's not quite as straightforward as just registering. You do need to have a detailed look at the market for sure.
Yeah, and so unregistered rights important need to be checked as well. Don't just be checking and seeing there's no trademark and going, oh, I'll have that one.
Yeah,
great. I'm just going to have a little check in with Luke and see if we've got any questions in the comments. Oh, we have quite a few.
Here come the carefulls.
Are you ready for this?
Yeah, go on ahead.
Get your study books out. No, I'm joking.
So first one, the last one's coming.
Yeah.
Callum Williamson.
From Callum Williamson, we have your question.
What happens if someone trademarks a shorthand variation for a word as a wide variation of trades listed under the trademark, but does not
Hang on, we're going to have to do this. We're going to have to do this sentence at a time. Okay, start again. First sentence. I can't remember all that. What happens if someone trademarks a shorthand version for a word that has a wide variation of trades listed under the trademark?
But does not currently trade in any of the businesses.
But does not currently trade in any of the businesses.
Does that make sense?
Does that make sense, Ryan?
Yeah, I mean, it's a lovely first question. Thank you, Callum, as well, by the way. So, yeah, I would, I mean, I'll have to have a detailed think about that, but just shooting from the hip, I would say that if I've understood that question correctly, it's a shorthand version of a particular name in an industry. It sounds like the name is already trademarked because he's made reference to some particular industries that it might be protected under. It goes back to the really easy principles of, is it descriptive in the context of how it's going to be used? You know, so that particular shorthand version of the name, is that, you know, shorthand for a descriptive term of what it's doing? And is it commonly used in the industry? Those are the two things that I would look at, and that's the area that I would assess it under. along with, is it already registered? You know, so somebody
But
already.
if they got it through, I think what he might be referring to is, like, for example, if I've got Smooth and I've just picked 10 categories and just gone, yeah, trademark, Smooth, and I'm not actually trading any of those companies, but I've just trademarked them all.
Got it. So what you have there is somebody that's obviously sitting on the trademark, and what you can do there is you can apply to get that trademark revoked. Now, the bad news is, for revocation, you usually have to wait 5 years for that particular trademark to be in place before you can challenge it on the grounds that you don't believe it's being used properly in accordance with the classes that it's been secured under. So for Callum, I would say have a look at the date that that trademark in question was registered. If it's 5 years or more, you could be looking at a potential revocation action there to actually get that pulled. So, but
great, that's really interesting.
Yeah, no, that's fine. But Callum, you know, if that doesn't answer your question, or if you'd like to hear more, just connect with me. I'm very happy to have a chat with you about that.
Amazing, love that question. Thanks, Callum. Right, next one. Is the next one as long? I'm not very good at remembering this. They're all quite long. Okay, we'll do sentence at a time. Sentence at a time. Unless I just unmute you, and then can everyone hear you?
Awesome.
Okay, no, got them.
You have some fluids, Ryan.
Sorry, guys,
prepare yourself.
I'll try and get to them all.
That's all right.
A lot have just come in. Okay, I've got Callum's done. This is from Leander. How do you deal with someone who has copied your name? Celtic Bookkeeping and Accountancy is trademarked. They have set up as Celtic Accountancy.
Okay, how do you deal with someone that has copied your name? Celtic Accounting and Bookkeeping is trademarked, and someone is set up as Celtic Accountancy. So Celtic Accountants and Bookkeepers is trademarked. Yeah. Over to you.
Trademarks, great news, because bookkeeping and accounting are very much, you could argue, similar industry, if not an identical industry, really. They work alongside one another. It's financial services in a way, isn't it? So,
it is. And
I would say that it's highly likely that consumers will be confused between bookkeeping and accounting. It's a bit like setting up Smooth bookkeeping. It's not going to fly, is it? Because you
I'd be fuming. I'd be straight on the phone to Dion.
Yeah.
Dion, sort out.
Yeah, go after them.
After them, yeah.
So, yeah, I would say that that's certainly worth looking into in terms of having a chat with the person that's using it against the trademark. I'm assuming that person is the trademark owner. If that person is the trademark owner, I would definitely be considering making that other party aware of the trademark rights that they hold, and I would give them the opportunity to change their name before you take further advice. So yeah,
always go in nicely to start with, I think.
Yeah,
it's just the right way to do things.
100%. Yeah, and it's more cost effective as well. You don't always.
No, you just need to be reasonable and come on, you know, you're using the exact same name. So Leander, if you want any advice or help, send him a DM. I'll also put all of Ryan's email address and details as well on this post later. But yeah, just connect with him on LinkedIn and get a bit of advice on that. Next one, Luke. You are being tested today, Ryan.
Good day to have a sore throat.
Switch to shots in a minute.
Okay, I'm going to unmute Luke so that you can just hear him directly.
Sure.
Rather than me repeat them. There we go.
Just coming from Alex Wilkins.
Hi,
Jerry and Ryan.
Yeah, go ahead.
Can you trademark a place name? For example, Portsmouth Accountancy Services or Southampton Legal?
Just FYI, you can't trademark Portsmouth Accountancy or Southampton Legal because me and Ryan will go mental. But just as generic question, then Ryan to answer.
humour there. So thank you, Alex, for
yeah, thanks, Alex.
Yeah, no, you can't trademark places, unfortunately.
Oh,
I had
know
this
that.
with a client a few weeks ago. He wanted to protect a particular candle brand from a particular area, and I said the problem that you have there is if you put the shoe on the other foot, you've now got a trademark for Portsmouth accountants. The problem that you now have is people like Jerry and others that are based in Portsmouth will not be able to refer to their business as Portsmouth accountants because they're going to be in fear of infringing on your trademark rights. And that, from a competition perspective, is really unfair. So yeah, it's a slippery slope when you start looking at, territories and using that as a name. So the short answer would be no. You could argue that Hampshire County Council is registered as a trademark, but that's a public body. So
okay, good. I did not know that. I'm learning so much. Great, thank you, Alex. Great question. Next one, please, Luke.
It's from Paul Clark. I have a client who'd like to trademark his company in his own name and then rent it back to the company, increasing over 3 years with the option of selling it back to the company with a 10-year inflated cost. Could he do this and trigger the entrepreneur relief?
Well, that's a bit of an accounting question. I wasn't prepared for that.
This is there we go. From a legal perspective, how you would do that, and we see this quite a lot actually. And particularly when you look at large organizations like Facebook and Google, you'll find that a lot of their intellectual property sits in an offshore company or in a holding company, and the holding company will then have a license agreement with the subsidiaries, which will deal with the licensing of intellectual property. In Paul's case, it sounds like his client wants to hold the trademark in his personal name or via his own particular personal service company, or whatever it is he's got. That's fine, as long as he has got a license in place with obviously the other company, and he's discussed that with the board as well. So there isn't a conflict of interest. There's no secret profit. As long as that's all minuted and the company's happy to take a license from him and his other company, fine. But from a tax perspective, I'm going to throw that ball straight to you, Jerry.
Thanks. Just quickly on that, do you guys deal with licensing agreements and stuff as well as all? Yeah.
We do assign licensing. Yeah.
Excellent. Because I might need that, as I might be moving my IP into my holding company. In terms of the entrepreneurs relief question, I don't know off the top of my head. Sorry, Paul. It would have to meet the requirements for entrepreneurs relief, which I think there's 3. I think it has to be a trading company. So as long as it's held in a trading company and you meet the other requirements for entrepreneurs relief, certain period of ownership, 2 years, I think, and minimum 5% holding rights, then you would get entrepreneurs relief.
Yeah, I love how you didn't know the answer, but you did know the answer.
It's one of those things which happens to me on a daily basis where I'm like, I sort of know, but not 100%. And that's why I have much cleverer people that work for me that do know the answer to these questions. So yeah, put me a DM, Paul, with the question, and I will get you the exact answer if what I've just said is a load of rubbish. Luke, do we have any more?
That's all the main questions for now.
Okay.
I'm putting these from LinkedIn notes, so people on YouTube, if you're watching, to LinkedIn. Yeah,
sorry. And also, if people are watching this after the live has ended, again, connect with Ryan, pop him. You're probably going to have loads of DMs after this. Sorry, Ryan. Pop him a DM, ask him the questions, book a call in. It doesn't hurt to get a bit of advice. I would really recommend that with something as important as this. But that's good. I mean, we've been going for like 50 minutes now, so it's longer than we normally go for. So that's great. I think we'll start to wind it up if there's no more sort of main questions on LinkedIn. But for me, smooth. I wanted the intellectual property as well, just thinking that who knows what will happen in the future. I don't have any intentions of selling Smooth, but if I did want to sell it in the future, you almost want it packaged up. Like, here's Smooth, here's the brand, here's a trademark, here's everything. And I think that's an important thing that people don't always think about, is way in the future, not necessarily right now.
You've made a really, really good point. I'm gutted, actually, that my brain has only just triggered on this point right at the end. So for anyone, fabulous, because this, for a lot of business owners with a big vision, this is the main driver for sorting out your IP. It's thinking about your exit. When it comes to exiting your business, your buyer is going to have their lawyers crawling all over your business. The lawyers are there essentially to justify the fees that they're charging your buyer. So they're there to try and find issues to drive the value down. One of the easy ones to drive the value down is if the other side's lawyers see that your company has not got itself together with its intellectual property. And that's things like the trademarks, it's things like the copyright and having appropriate licenses in place where needed. It's looking at the ownership structure of your IP and making sure that it's all been packaged properly and you have a proper portfolio that's managed so you can point to it all. If you don't have that, it can be a can of worms, and it increases the risk for the buyer. They're thinking to themselves, right, I'm buying a business that's got no IP protection. So how do I know I'm not going to be sued for infringement if I buy this business? You can have indemnities, obviously, but unfortunately, in that regard, they usually carve those out. So,
yeah, super important note to finish on there. Listen, thank you so much for joining me today on the podcast. I've absolutely loved it, and you know, it's been a pleasure working with you over the years, and we will absolutely continue to do that. Anybody still listening, connect with Ryan on here. Send him a DM if you want any advice at all. I will put Ryan's contact details in the comment section as well. And yeah, I'm just so grateful for you joining me, even with a sore throat.
No, I know, but thank you so much. You know, it's been great to obviously just have a casual conversation with you, and hopefully the listeners have found it useful. You know, and the main thing is they just go away and have a think about their brand. That's the most important thing.
Absolutely, yeah. Everybody, go away and have a think about your brand. Cool. We'll finish there. Thank you so much, everyone, for listening.
Thank you.
And yeah, see you soon.